On appeal, should SEBI, if at all SEBI takes it to the Supreme Court, should their case be that this categorization in itself is on shaky ground, and if you proceed from there, what SEBI has brought forth in terms of evidence will be enough then to find the auditors culpable?
Okay, so firstly, definitely if there's one legal issue which will go up to the Supreme Court if SEBI decides to do so, I think this will be an legal issue that comes up to the forefront, because this is something that needs to be articulated by the Supreme Court. And to me, the SAT decision seems to be going against the basic grain of the three Supreme Court decisions which lay down the burden of proof. As to your question on whether the evidence before SEBI and SAT is sufficient or not, I think that seems to be something which needs to be reconsidered. The way I look at it, the SAT has laid down a very low burden on the auditors, whereas SEBI in its order of 2018 has placed a very high burden on auditors, where they say almost gross negligence equals to fraud. But I think to me the answer lies somewhere in between. So I think the Supreme Court will have to lay down that standard, and it remains to be seen whether SEBI's evidence that it has so far will be sufficient or not. Certainly it's not been able to establish the standard set out by SAT, but whether a lower standard will suffice or not remains to be seen. My own personal opinion is that the SEBI's order was also based on a lot of conjecture and trying to link up negligence with fraud, and that might just not be sufficient.
Okay. Mr. Ramesh, do you want to weigh in on some of the grounds of appeal that SEBI would probably, if at all goes to the Supreme Court, would like to bring up?
Yeah, I think the first thing is about a distinction between a person associated with the markets, a person directly dealing in securities. I think SEBI will have to raise that issue at the Supreme Court, because the way I have read the Baldev Patel order, it's that there are entities who are not actually dealing in securities. So the Supreme Court precedent is already there, but even if you are not dealing in securities and you are associated with the securities market, a preponderance of probability is sufficient. So this order has been ignored by the SAT order. So SEBI will be raising this issue. I think the other issue is that if you're going to have a standard which is beyond reasonable doubt, you have to prove. I think SEBI is going to have problems with not only auditors, you'll have a problem with directors. So because directors are not regulated by SEBI, you're going to have a problem with independent directors. You'll have to have a problem with promoters who are not dealing in security, but SEBI, most of the cases says they are complicit in the fraud. So this is going to dilute the SEBI's approach to regulation in a substantial way. I don't think that is the intention, because the same order, the Baldev Patel order, reads what is a fraud and what is SEBI's power in a very extensive manner.